Many clients will come in and ask if it's possible to prepare what is called a separation agreement or a property settlement agreement. Generally, separation agreements are now referred to as property settlement agreements, and that is generally going to be a less costly procedure than if you have if you have litigation. You conduct discovery and have litigation, or in fact have a trial in which the court determines how the assets are going to be split. A property settlement agreement is generally going to be negotiated between the parties after having either full or limited discovery. There are instances where the parties may be trying not to spend a lot of money on paying counsel fees and whatever other fees incurred in having adequate discovery of the party's assets. They may simply know. It may be where both parties are regular employees that don't own businesses and don't receive outside income. And in those instances, simply by looking at the tax returns and the bank statements, checking accounts, you can, and 401k or pension plans, you can generally know what the real assets of the marriage are. If there's a home, having the property appraised. Having done that, the parties can then negotiate a property settlement agreement, which also would include other items, such as, and most important maybe, parenting time, custody, child support, those other items. And once that's done, then the divorce is a simple matter. The property settlement agreement is reviewed by both parties, signed off on, and then when you have the actual divorce put through, the court will question the parties on the agreement, and if the court is satisfied that the agreement was entered into voluntarily and knowingly, the property settlement agreement will be made part of the final judgment of divorce.